Hi friends, I'm Advocate Shreyas Rao. I shall be speaking on bail jurisprudence in India. Well, it is a settled law that bail is a rule and jail is an exception. We follow an adversarial system of criminal justice in India, and the theory of adversarial criminal justice system is that we begin with presumption of innocence. An accused should be presumed innocent until he is proven guilty. And why should an accused suffer pre-trial conviction when his custody is redundant, or he should be incarcerated in custody for unjustified reasons? Yes, there are certain stringent legislations like UAPA, NDPS, NCOCA, where there are issues like national security, there are instances of repeat offenses, serial rapists, where the courts have to be circumspect while granting bail, where the court has to take into consideration issues like the accused has the propensity to repeat the offense, being a serial offender. Second is the accused might not make himself available for trial. He may abscond. And third is the propensity to tamper with evidence. Now, if these three exceptions are there, then yes, the court is convinced that it is not fit case to grant bail. And there is, of course, another concept of bail, that is an anticipatory bail. When an individual feels that he would be framed by an individual, he files an anticipatory bail, and the court believes that yes, it is a fit case that this individual could be framed. And on the other hand, the prosecution says, the police says that no, it's not that he merely has an apprehension he could be framed. There is prosecution, there's adequate amount of prosecution. We have a complaint. We may require his custodial interrogation. So it would not be appropriate to grant anticipatory bail. If you grant anticipatory bail, it will defeat the purpose of custodial interrogation, and so you ought to not grant anticipatory bail. So the court gets into a dilemma whether to grant it or may not grant it. In certain cases, when there is no want of prosecution, there is no complaint, there is no NC complaint, there is no written complaint, or there are certain cases where the police just calls the accused for a preliminary inquiry, and the accused, not even, he gets worked up and not even complying with the preliminary inquiry, files an anticipatory bail, and the court rejects the anticipatory bail, says that comply with the preliminary inquiry. In the preliminary inquiry, the accused will not be arrested. So, and when the person unnecessarily files an anticipatory bail, it gives rise of suspicion to the investigating officer and the court that there is something fishy. So at the end of the day, bail jurisprudence is such. Of course, one thing I need to mention is that if there is a lapse, if the investigating officer or the fails to file bail within a stipulated period of time, the accused gets bail as a matter of right. So he has to file bail within a stipulated period of time, that is with reference to the nature of the offense. And there's one more thing, that people have this notion that if charge sheet is filed, then there is a great likelihood of getting the bail. Yes, in majority of the cases, but there is no provision in law that if charge sheet is filed, bail is mandatory. There is no such provision that if charge sheet is filed, bail is mandatory. But coming back to the point that, you know, if a person could have an opportunity, or could there be a possibility of his acquittal, unnecessary incarceration or he languishing in custody is uncalled for, and bail should be granted. Otherwise, it amounts to curtailing of liberty and violation of Article 21, which is the soul and bedrock of fundamental rights in the Indian Constitution. Thank you.